I particularly want to thank the organizers for asking me to comment on this paper, because I think it's the same paper as Judd, Steves, and Wills from yesterday, maybe a slightly more tentative in some respects, but I think it's the same subject. And even though I raised my hand, I could have sworn like 30 seconds into it, I was so late on the queue, I didn't get to ask any questions. So I'm very grateful. I can comment on both papers at once and ask some questions of both papers, because both papers rely on this idea of general citizenship rights. And I am, as of yet, unpersuaded, but persuadable, but not yet persuaded. And I begin with a question that Larry Solomon and John Mikhail put yesterday, and I didn't. And I'll tell you what I thought I heard the answer. And their question was, in what sense are these general rights different from the common law, general common law rights? And I think, maybe it's just me, but part of this, behind this, is I don't actually remember any references to general law outside of the context of the common law in the antebellum period. I haven't gone and done an F1 on everything written in the antebellum period, but I can't remember it in any event. These all seem to be references to the common law, and I certainly never heard the particular formulation, general citizenship rights. Those words I don't think even appear. And so what was the answer? If I understood Steve correctly, his answer was, the reason we use the term general rights is because we are 2023 teachers of federal courts and some other subject, and that's common vocabulary for law professors about this today, and so it's convenient to use that term. They know what we're talking about. And I would just urge that when we're doing originalist analysis, let's use the vocabulary of the people at the time we're talking about, and not project onto it a vocabulary that may be familiar to folks today, but may also import different meaning, maybe accidentally, but I think possibly missing out some of the answers to these puzzles that are to be found in the concept of general common law. And I think the idea of general common law explains almost all of the things that they find puzzling. And so John says, are there any of these strange legal creatures which are these general rights which are protected against the states and so forth? I don't think there's any need to create a new, monster book of legal concepts. Let's stick to the ones we've got and look at what the implications of them are. So the way I understand general common law is that we inherited the common law of Britain. It speaks to all of the important questions addressed by the Civil Rights Act of '66 and almost all the ones in Corfield versus Coryell. And there's a lot of coherence to it, but it does vary from state to state in its details. All of us agree about that. That's not in dispute. It also seems to me to be subject to abrogation by states. I think the rule, basically this means by state legislatures, and I think that's the reason why I'm a little less confident of that, but I think that's the reason why in Swift against Tyson, federal courts are said to be bound by the legislative acts of the state, even though not necessarily by the common law interpretations of the general common law within the state. But this explains how you can have transjurisdictional law that governs real cases. It's actually authoritative. It's not mystical in any way, but is subject to state-by-state variation. And I think, the Privileges and Immunities Clause of Article 4, which I'll just refer to as Article 4 to be fast, I think Article 4 is actually a brilliant solution to how to create a common market in the United States without giving federal courts authority to superintend the details of the law in the various states. Just say whatever whatever you give to your own citizens, you have to extend to the citizens of the other states. By the way, I do not understand at all why John entertains the prospect that that Article 4 should be read. He says, interpolating words into the clause, that it should be read as if it refers to the privileges and immunities of citizens of the United States in the several states. It doesn't say that. There is no reference to citizenship of the United States whatsoever. The only federal aspect of this is that the federal government, through the Constitution, insists that the states be non-discriminatory against members of other states. The people of the other states get their rights, it's pretty clear from the language of Article 4, by being citizens of other states, not by being citizens of the United States, but of other states. That's what it says. So I don't really understand why general law is being treated as a strange new legal creature when when general law is something that has been well understood, makes perfectly good sense of Swift versus Tyson. Erie, by the way, I think is right to reject something called federal common law. There's no such thing as federal common law, but that isn't to say that there isn't something which is general federal law, even if Holmes found it a little difficult to understand. So that's my first point: is why are we talking about why don't we understand that the general law that is referred to as in fact common law? Second question is, how does natural law fit in? And it seems to me natural rights fit in. And I think the conventional understanding, there are some deviations, but I think the conventional understanding is that positive law trumps natural law. There is such a thing as natural law, and it can be enforced in courts sometimes, but not when there is, and I think Rutgers against Waddington in 1785 is it may not be the most important case, but it's the clearest case in describing this. Basically, the natural law governs, in that case it was the natural law of nations, but that doesn't matter. The natural law governs unless the legislature has done something specific enough and intentional enough to override it. Now, why those qualifications? A general statute where the legislature hadn't focused on the application, they say quod hoc, and that I think that's what we would call an as-applied challenge. If the legislature is just something general, then you say, well, still the natural law hasn't been displaced. But if the legislature is really thinking about it and says, yeah, we really intend to override the natural law, it governs. That's why slavery was okay, even to people who believed that slavery is in violation of the natural law, like, for example, Lord Mansfield in Somerset. When there was an explicit piece of positive law authorizing slavery, well, okay, we may not like it, but positive law trumps natural law. And so I don't believe, and I think also that many of the cases where it looks like unenumerated rights are trumping state law in the antebellum period, if you look carefully at it, I really think they're doing a Rutgers against Waddington. That is, they're saying this principle is so important to justice, you can't take from A and give to B. This is so fundamental to justice. We just will not will not interpret the legislature as having overturned that. It would require a lot more evidence for us to think that the legislature in a free country would ever do something contrary to these fundamental principles of justice. I do not think that means that in principle the legislature doesn't have the power to overturn the natural law. So, the next question. So, what is the Privileges and Immunities Clause of the 14th Amendment doing? And John seems to think that this requires some explanation because we need an answer for the slaughterhouse dissenters. He said, well, there was this article back in 1992. I forget the author's name, but some of you may remember the article. I thought it was a brilliant article, taught me virtually everything I ever learned about privileges and immunities. Who was the author? Do you remember by any chance? Do you know this article, John? That answers this question, right? And so what Article 4 does is it protects the privileges and immunities against discrimination against out-of-staters, against citizens of other states. So the citizens of each state are entitled to them. And the 14th Amendment, which just made former enslaved people citizens, and that's really so they are now citizens of the United States. And what the 14th Amendment Privileges or Immunity Clause says is, and what's more, you have to extend those privileges and immunities to all citizens of the United States. Same set of privileges and immunities, same sort of logical structure, but now it's a different kind of discrimination. It's discrimination against some people who are citizens. And the dissenters in Slaughterhouse look at that and they say, yeah, that's what it means. And this idea that it's just federal rights is preposterous because federal rights are already protected under the Supremacy Clause. You don't need the privileges and immunity. So the majority in Slaughterhouse just doesn't make any sense. And so they look at the slaughterhouse situation. This is where I find it a little unpersuasive, but they look at the slaughterhouse and they look at it, at that regulation, as saying this monopoly company gets to butcher, but nobody else. And so it's treating citizens of Louisiana differently. Some people can butcher and some can't. That may be weak reasoning, but the basic structure of analysis of the 14th Amendment seems to me to be sound. Where does this leave us then? What good is this new approach? I love Judd Campbell. He's a good friend of mine, but I don't understand why this general rights approach is doing us any favors. First of all, I don't really see it, other than common law, I don't really see it in the history. But then secondly, I don't understand what puzzles it is solving. It does nothing to get us toward a privileges and immunities version of substantive due process, which is to say judges being able to decide that principles that they think are really valuable trump state law, that the states are not able to, that these rights are immune to state legislation, because the general law was, as John keeps saying, that the states have some power to alter these rights. Some, he uses the word some over and over again. I say they have total power with respect to general common law rights, because legislatures can change the common law, whether it's general common law or local common law, doesn't matter. So I don't think it gets you, unless we can identify some source of law which does trump state law. It doesn't come from the common law. It doesn't come from the 14th Amendment, because we know what the 14th Amendment means, and it doesn't mean that. I don't know where it comes from. So, and then the other puzzle is incorporation. Now here I do think the general rights vocabulary may contribute to a solution of what Jack Balkin yesterday helpfully called the problem of can the Privileges and Immunities Clause walk and chew gum at the same time, by which I think he means protect both the privileges and immunities as understood in Corfield versus Coriell, and also incorporate the Bill of Rights. These things look so different. So Judd's theory, if both of these sets of rights can be put under the general heading of general rights, I don't know if they can persuasively, but if they can, it at least means that the Privileges and Immunities Clause is not walking and chewing gum at the same time. What it's really doing is chewing two different flavors of gum at the same time, which is an easier proposition. But I also don't think it really solves the problem that we worry about today, which is just, has the Supreme Court just gotten it really, really wrong? Because I think this theory is completely, not only inconsistent with, I think it refutes the idea of jot and tittle incorporation. Because as I understand the theory, there are underlying rights, like the freedom of speech, that Congress, the Bill of Rights doesn't create them. Bill of Rights only says Congress can't abrogate them, abridge them. And now the 14th Amendment, under this interpretation, says the states can't abridge them either, but we understand all general law is subject to state power to have variations and so forth. And so even if you don't think they can do total abrogation, they can surely do variations. That's the whole theory. I don't think John disagrees with that. And so under all of this, if you want to come with us that far, I think you're left with an incorporation theory which allows state-by-state variation as to the details. And the U.S. Supreme Court is completely opposed to that, Ramos versus Louisiana being the most recent case. They don't allow deviations in the jots and the tittles. And I think that the Campbell, Harrison, Bode, Sachs way of looking at things doesn't actually rescue the Supreme Court. I think it makes the Supreme Court just even more plainly wrong than they looked before. Thank you.
Thank you. The first thing I want to say is that Campbell, Bode, and Sachs are a lot more interesting than Harrison. And I think that what I have to say is significantly more modest than what they have to say. The main point I want to make is to separate the claim about meaning from what I think is also necessary to produce substantive protection for unenumerated and elsewhere enumerated rights, claim about other parts of the legal system, the funny stuff, the monsters. So that's the first point. Second point, whether or not general law is an authentic antebellum category, general citizenship, they talked about that. And that is authentic. And the theory, the ellipsis theory of Article 4, developed in the antebellum period, that it implicitly includes the words of the United States and talked about during the Reconstruction debates. So that's real. I'm not saying that the 14th Amendment necessarily picked up, Justice Miller said it didn't, necessarily picked up the ellipsis theory, which was in circulation at the time. My point is the ellipsis theory was in circulation at the time. And so that's certainly a possible reading of the 14th Amendment. And so one of the questions I want to make sure to raise is who was right about that? Was Miller right about that, or is that the ellipsis theory being used in the 14th Amendment? As for states' power to abrogate natural law or general common law, and maybe I need to be more careful about this, I try to say it's clear, and this is an important part of my argument, I think, that the states have at least some power to do that. It may be that they had complete power to do that. If they did, then there weren't any of those funny things. There weren't any monsters. and we can all, don't worry about them being under the bed tonight. We can all sleep well, knowing that there were no rights of citizens that were immune to the legislative power of the states for reasons other than federal law. Maybe there were, maybe there weren't. Again, my position on that is skepticism, but not an absolute denial. I suspect Mike may well be right. The main thing I want to say is it's necessary to see and answer that question. Were there any monsters out there? What about the equality-based reading of the Privileges or Immunities Clause? It's still correct, and it is correct even with the ellipsis reading, even if there are rights of general citizenship, because and even if, as I believe, the states have substantial power, maybe complete power to define those rights, both those rights and the actual rights of state citizenship, which I think are picked up for citizens of the United States because they also get state citizenship, are subject to an anti-discrimination rule that comes out of the concept of abridgment, and that's why I said, yes, one thing that does qualify as an abridgment is taking away from some citizens the rights that others have, whether those are general citizenship rights or whether they are state citizenship rights. So the equality-based reading, I think, is definitely intact. What about incorporation? I think one of the this can be the last thing I'll say. I think one of the important features of this understanding of general citizenship rights is that it demonstrates that the only really plausible theory of incorporation is not a jot for jot, and people have said this, is not a jot for jot and tittle for tittle theory of incorporation. And to the extent that the Supreme Court says to the contrary, well, they're not doing the original meaning correctly, on the premise that there are the general citizenship rights in there at all.